Hello, everybody. Thank you for joining us. So happy to be seeing so many people online. And with me, I have eminent speakers here today. Very excited to have the whole lot of people. So we'll give it one more minute for folks to join. Madhura, you're there. I can see you. I think we'll give it. I think, Madhura, we can get started.
Okay.
But
Hi,
I can't. Yeah, okay.
Can you see me now?
Yes, perfect.
So, hello everyone. A warm welcome to today's session where we are here to learn some important laws related to you together jointly by. Am I audible?
Your voice is dragging.
Am I audible now?
Yes, much better.
Okay. Okay. I'm so sorry. Something is wrong here with my network and the devices at one time. So yes, myself, Madhura, I am from Indian Lawyers Association. We are the organization or profession by giving various lawyers. We work on the model of having chapters in different cities all over India. We currently have 75 chapters. And there are several initiatives that we run to provide mentoring to young lawyers, law students. They come to us for different kind of guidance they require for their career. We host different legal aid initiatives. So we'll be very happy to send you a detailed email by tomorrow, or you could even check us on our website at indialawyers.org. I hand it over to Smita, who has been a great moderator throughout this discussion series by Aileen Kelpechar. Smita, over to you. Thank you.
Thank you so much. Thank you for taking your time out on a Thursday evening and joining us. Thank you, Madhura, for that introduction. And today I'm very, very excited. I have some amazing people on panel, and the subject is also very, very close to me. So let me start by introducing myself and my organization. I run a company called Kelp HR. Kelp HR we started in 2013, the year Posh Law came to us, right? From then to now, 2021, we have partnered with 550 plus organizations pan India, and we are growing strength to strength. And we realize that if it's just one law that we work with, but there's so much of work in that space. We of course work in the space of DNI and employee assistance program as well. A little bit about me. I have total of 23 years of work experience. Last year, I got listed as a global diversity consultant. It was, something very, very prestigious for our country also, because diversity is hush hush. And the most important part of diversity is women in India. In India, we are struggling to build or put our foot strongly. So POSH is a natural offshoot of that. And here is my eminent group. If you can see, we have four power-packed people whom we are going to speak about today. So first and foremost is my professor. I'm very, very proud to be part of introducing her. She is Professor Dr. Asha Bajpai. She's former founder, dean, and professor of law at TIS. She completed her graduation in science with statistics and economics, and her post graduation was in law and business management. She did short term stints as management trainee, junior lawyer, sub editor, visiting lecturer, and then finally she got her MPhil and PhD in law degrees. So she has specialized in child rights and access to justice for vulnerable lot. Okay, so when she retired from TIS last year, that's she has written a lot of business papers and she's written a couple of books. I can go on, but I will have to stop somewhere. And she is constantly working, and she's a founder member of South Asian Network of Justice and Education called SANJE, Sanjay. So that's about her. I also have with me Mr. Harish Sadani. He's an Aspen Fellow, co-founder and executive director of MAVA. MAVA stands for Men Against Violence and Abuse um, Against Women. So he is a leading gender rights activist who has pioneered efforts in India in 1993 as the co-founder and executive director, uh, where he works with young men and boys and how to prevent violence against women. He's a TEDx speaker and has been invited on various forums, national and international bodies like UN Women, UNFPA, to share his insights. So Harish has been awarded of Ashoka Change Makers Award in US, um, Maharashtra Foundation Award, the Mukta Sanman, and he also writes in a couple of news articles. Lokmat is a news channel where he also writes. Right, so that's about Harish. Yeah, we go way back in 2013 when we were trying to set up Kelpechar, when I had consulted Harish too. Uh, the next eminent guest on our panel member is Kanti Mohan Rastogi. He's an advocate, Patanjali Associates Law Firm. He's a former executive VP Legal Global and Company Secretary, Hinduja Global Solutions Limited, with over 30 years of experience across the legal spectrum. Kanti has headed legal departments or corporates of Hinduja Global, Coca-Cola India, and various other companies as well. He is member of Bar Council of India and Institute of CS of India. He is also an insolvency professional. He was awarded Leaders of Leader by Global Forum of CEOs and Vertical Heads of Hinduja Global Solutions. He has spoken on various forums of Bosch, including NHRDN, PhD Chambers of Commerce and Industry. He has been taking POSH sessions as well. And the most youngest guest on this, and I was so excited to read her profile. When this came to me, I was like, oh wow, oh wow, oh wow. So that's Aishwarya for you. So she is a associate IC Universal Legal, general corporate and regulatory transactions, mergers and acquisitions. Aishwarya has worked in M&A for general corporate team in ICUL. Um, so that is what she's done from her career perspective. Now let me tell you about non-career aspects. So she's a national level table tennis player. Okay, wow, Aishwarya, that's so interesting too. I was so excited when I read that, right? She went on to become the convener for sports committee, and she's been working in the space and promoting sports across. So she's a voracious reader. Um, Fiction, astrophysics, metaphysics, Indian mythology, religion, and philosophy. This is her interest. She's a self-proclaimed Potterhead and occasionally likes to indulge in theater. Wow. She's when she's not doing all this like baking, tempering of chocolates, painting on canvas, she also does swim. So this is our full package of folks today. Very exciting people. I know, a little more than 5 minutes to introduce them because they were so power packed, and I really wanted each one of you to know that what these people do. So coming back to our subject, this subject has been uh, with me, close to my heart, because a lot of people, a lot of women on day-to-day basis, when I meet, and I realize that they don't even know what are their rights. Is Can we start a forum where we start speaking and start educating women about their own rights? So I thought, let's get together, let's break our head. Maybe we won't get solution in session one, maybe not in session two, but it has to start somewhere. So this is a forum where we thought, let's get started. So my first question is to my professor, Dr. Asha Bajpai. I remember studying law with her in 99, so way back. And I remember that her best part is she simplifies things. Okay, and that's what I picked up from her. A person who is very good at it simplifies it for others. So I said, let me start with her. So my first question to you, Professor, is that if I have to take an action against any person who's bothering me legally, I'm a woman, okay, what should I do? Is there something, what is this NC, FIR? Do I have to go to the same jurisdiction where the issue has happened? It is so much of confusion that I run away from police, right? Going to a police station is not something that I like. So what can we do is a question to you.
Thank you. Thank you, Smita, for this very, very kind introduction. I'm also proud that I had a student like you who has done so well now today. You are doing excellently. Okay. So I'll answer your questions. I have a presentation which I'll share. I'll begin with how is all of you feeling today? Just maximize my thing. How is everybody feeling today in this group? I know many of you have come from work, many of you have come from different places, and the atmosphere outside is so bad. Many times you feel happy, sometimes you don't feel happy, sometimes you feel sad. So this is how we begin today, how we feel. I think all of us are feeling okay today. And so we just go to the next slide that I have, and that is...
Ma'am, there are few in the chat box. Somebody saying tired, waiting for the day, I guess,
Okay.
wants to say, waiting to take a vacation. And there are some people saying they're feeling good.
Okay, very good, very
feeling
good.
Cerebral, feeling good, eager to learn. So these are some of...
So my screen is visible, isn't it?
Absolutely, it is visible.
Okay, okay. So I go ahead and I just go to the next slide. Oh no. How did the screen sharing stop?
You have to just share one more time, maybe.
Okay, okay. I just shared it again. It stopped, I think.
Yeah.
I'm so sorry why it is.
No, it's perfectly fine. Take your time.
It was there earlier. Sorry about it.
Can you see the green screen which says share screen?
Yeah, yeah, I can see that. It was there and suddenly it got stopped.
No problem. You have to share again.
Yeah, I'll have to share again. Is it coming now?
I can see not your PPT, but
the folder screen is there, but you need to click on the folder screen now.
You have to share the PPT, ma'am.
Yes, I'm sharing it, but somehow it is not coming. So always it's shared, came in the beginning, it went off.
No, I can see your screen.
You click on the folder screen now, please.
Yeah.
I can see your screen, but it shows me legal awareness Asha Bajpai presentation. But
the presentation is not coming.
No.
Oh, I don't know what to do now.
No worries. You can double click it and open the file and then share the file, share that screen.
Yeah, I did that. It is letting your screen sharing, but why it is not coming?
Your screen is shared, miss. So stop share again. Will you click on stop?
I'll have to stop share. Okay.
Yeah.
I'll have to stop
and share the PPT.
Yeah.
You have shared the screen, but you've shared the other screen.
Is it coming now?
Yeah.
Yes, it is there.
Okay, fine. So As Smita said, yes, we are all feeling complicated. We feel law is something very, very complicated. We are so scared of law. Or some of us feel we don't need law at all. We are such good people. We'll never come in contact with the legal system. But there are situations where you do come in contact with the legal system. And as Smita said, that the first thing is that we should not be ignorant of law, which is no excuse to not to be hauled up in any legal situation. You cannot say, oh, I was not aware of it. That's not the excuse that you can give. You must be aware of some of the basic laws and rights that you are there. It empowers you. It empowers you. Okay. So this is an example that I'm taking. He talked about if somebody is legally harassing you. An example that I've taken is you are walking on the road when suddenly a man stops you and demands your wallet, which has your money, cards, valuable documents. On refusing, he pulls out a knife and threatens to kill you if you don't hand over the wallet. Fearing for your life, you hand over the wallet. He takes it away and runs away. What will you do now? Can you answer very briefly in the chat box? Smita, you can let me know what's happening in the chat box. Very briefly, it's a quick right thing, maybe
Yes,
2
yes.
words, 3 words.
Yeah, they're saying we'll report to police, file a complaint,
Yes,
file a FIR.
file FIR.
I will
Okay.
report to nearest police station, file an FIR with police, ask someone to call 100 and block the card, call the
Okay.
cops, file a complaint,
Okay,
file a FIR, police
File an
complaint,
FIR.
call the police,
Fine.
call 100.
Call 100. Fine. Okay, very enlightened group we have over here. So this is how you generally, whenever there is an offense which is cognizable, then you file an FIR. Now, what we come to the different kind of offenses, you can't file an FIR for all offenses, okay? There are certain offenses for which you have filed an FIR, and these are called cognizable offenses, okay? And in cognizable offenses, the police will file an FIR. In non-cognizable offense, you must have heard of that great word NC. You get an NC, okay? Many of you come back with an NC. For example, you lose your mobile and you go and file a missing complaint in the police station. They'll file a complaint. They'll give you an NC. They'll give you a copy of the complaint that you have filed. But FIR means a complaint, first information report of cognizable offense, like serious offenses like rape, theft, murder, theft of a huge amount, murder. All these are very serious offenses and they are cognizable offenses. And in these offenses, they'll write an FIR, first information report, which starts the criminal justice system into motion. And other offenses like simple hurt, fight between two neighbors, abusing each other, slapping each other, and no bones broken, blunt instruments are used. These kinds of are non-cognizable offenses. Now, the difference between the two is that in cognizable offense, they immediately start the investigation. They'll go to the scene of crime, they'll start inquiry, after registering the FIR, and they'll start the investigation. Okay, but in a non-cognizable offense, they'll make a note in the general diary in the police station, give you a number, but they will not start an investigation. They will go, you will have to go to and take a permission from the magistrate for them to start an investigation. Okay, so the difference is that the non-cognizable offense are not those serious offenses, but cognizable offenses, they'll immediately start an investigation. So you can only file an FIR for a cognizable offense. So in this case, the victim whose wallet was stolen, that victim can file an FIR, or anybody who was a witness can file an FIR. And somebody whom you had confided to and felt that, yes, a cognizable offense was committed, they can file an FIR. So when you have a list of cognizable offenses, non-cognizable offense, there's a schedule in the Criminal Procedure Code. In that schedule, you get a list which is cognizable, non-cognizable, bailable, non-bailable, which court you need to go. So that list is followed by the police when they do it. So who can file? The victim, the person whom you have told, or any other witness who has seen. So what will you write in an FIR? the experience that is there is that when you go to a police station, sometimes they're so hassled many a times that many you don't remember certain things. So if you have time, if you don't have time, it's a very serious emergency situation, you rush to the police station or you phone 100. But if you're filing an FIR, you have to write your name, address, what happened, when did it happen, how did it happen. If you know the person, the offender, you name the offender. If you're doubting anybody, you tell that name. If there are any witnesses, you tell them the name of the witnesses. Read over the FIR and sign. And then you have a right to get a copy of the FIR free of cost. Okay, so this is about the FIR. So by the victim himself, herself, or the family relative, any other person who knew the facts, all this is, all these people can register an FIR. Now, NC. NC is a very common word. I hear many ladies telling me, NC ho gaya, NC ho gaya, NC file. So police, if there is an NC, NC is not that serious offense. For instance, you know, this is a very common example that we give. A blunt instrument is used and you get hurt, no fractures, no bones broken. In those cases, it is a simple hurt. But if there are bones broken and a sharp instrument is used, then it becomes a grievous hurt. And grievous hurt is a cognizable offense and simple hurt is an NC. NC is written in the police station, in the diary, general diary that is there. Copy of that number, NC number, is given to you, to the complainant, free of cost. Okay. In case of serious offenses, always remember, insist on an FIR and not an NC complaint. Okay. I have heard many women going to the police station, though there were like serious injuries. There were serious injuries on them, maybe of violence, of many other aspects. But I came to know of a case of dowry death. In that case also, they wrote an NC, saying that it is accident, it was nothing serious. But if it is a serious incident like dowry death, murder, rape, you have to file an FIR and not an NC. Okay.
Ma'am, I'm sorry to interrupt
Yes.
you, but there is one very important question. A lot of people do not understand what is non-cognizable and cognizable. So will you be able to explain that difference in simple words?
Okay. Your cognizable offenses are very, very serious offenses like murder and rape. And non-cognizable offenses are not that serious offense like theft, like suppose a scuffle between two neighbors, like one person was slapped. So these kinds of non-serious offenses are non-cognizable offenses in which an NC is filed. And for serious, they won't file an NC in a cognizable offense like murder and rape, they'll file an FIR. Okay. I remember a case, I'll just share it with you since you have asked this. I remember a case of a loss of mobile. It was in a cinema theater in those good old days when theaters were working. So people used to go and watch movies in theaters. So this lady had gone to buy some, in the interval, some popcorn or something. She left her mobile on the table and was paying something in the counter when somebody took that mobile, took it surreptitiously, and she couldn't get it afterwards. Now, when she went to the police station to file a complaint, they started giving her saying that it is just a missing complaint, non-cognizable. We'll give you a complaint and give it to you. But she insisted. She insisted it is a theft. It is a theft of a mobile that cost me around ₹1 lakh. And it was intentionally taken with an intent to rob me, to steal. And that is why it's a cognizable offense. It's a serious offense of an item that was more than ₹1 lakh. She insisted on that, and finally she managed to file an FIR. An investigation started because it was a cognizable offense, and the police started the investigation and found the mobile in the washroom of the theater where it was hidden by the thief. Okay, so that's the difference between the cognizable and a non-cognizable offense. Okay, so that's the list which I told you about in the CRPC schedule. That list is very important. So if Smita wants, we can share it with her so people can have a list of cognizable and non-cognizable. Yes, Kanti wanted to say something.
Yeah, ma'am. One thing is that in the cognizable offense, the police can arrest without warrant.
Yeah, I'm coming
That's
to that.
something that you may like to add.
Yeah. Thank you for that. This is a copy of a FIR that is generally there, where you write your name, address, husband's name, and all that, and what happened, suspects, all those kinds. So this is generally a copy of an FIR that is there. Now, for in a cognizable offense, the police start an investigation immediately. Now, and once they start an investigation, they can arrest without a warrant, as Kanti rightly mentioned. And in case of an NC, they will not start an investigation. They will not be able to arrest without a warrant. They'll have to arrest with the permission of the magistrate only. That's one of the other differences. Now, where to file an FIR, as Smita asked. You remember the fights that go on, the squabbles that go on when, you remember that Hyderabad rape victim, that veterinary doctor. The father of the doctor ran from pillar to post for filing an FIR, and they said, oh, it's not within our jurisdiction. But that's not the issue. The issue is, generally an FIR is filed in the police station within whose jurisdiction or whose area where the incident happened, okay, where the offense took place, the nearest local police station that you are there. But there is zero FIR concept. In the zero FIR concept, what happens is that it is given to avoid delay of any kind of disruptions. The police can take the cannot say that this is not our jurisdiction. They can file the zero FIR and transfer it to the relevant police station immediately. Okay, so this is to see that the case is proceeding fast. So a zero FIR can be lodged at any police station. So cops can't turn you away because of the zero FIR that is there. So many times you must have heard a zero FIR should have been filed. Similarly, in the case of that veterinary doctor, they could have filed a zero FIR, and that could have happened in that. And her life would have been saved. Her father said that if we had not wasted time running from one police station to the other, and police telling us that this is not within our jurisdiction, her life could have been saved. A zero FIR option should have been given to them, but it was not given to them in that case. Okay, and victim can, and then what happens is that the nature, so to file an FIR, you have to have a cognizable offense. Remember that. Now, registering an FIR. I remember the thing that the concept of zero FIR was actually started in the criminal law amendment in the Nirbhaya, after the Nirbhaya case, in the Justice Verma Committee report. Then afterwards, in 2015, the Ministry of Home Affairs issued an advisory to all secretaries of all states and union territories to instruct the departments concerned to compulsorily register FIR and also zero FIR if it is not within the jurisdiction. Okay, so it is made clear by the Home Ministry that a police officer is duty bound to register a case on the basis of information disclosing a cognizable offense. An FIR has to be registered irrespective of jurisdiction. Irrespective of jurisdiction. Okay, so zero FIR is something that avoids delay. It enables the case to proceed fast. Many of the police do not give you this option, but they should give you this option, and you must be aware of the zero FIR option. So while registering the zero FIR, the police records the statement of the person, records all necessary information, and a duplicate copy is given to the person without any cost. And if a FIR is not registered, even a zero FIR or any FIR, you can always approach the higher authorities. The hierarchy of the police is there. So the senior police inspector is at the hem of affairs in the police station, but above that you have the assistant commissioner, you have the DCP, then you have the additional police commissioner, then you have the commissioner himself. So you can always go and file a complaint there. If all this doesn't work, then you can write to the magistrate through an advocate. That also is possible. Okay, so zero FIR can be filed at any police station. Now regarding the arrest, Smita asked about arrest also. There are many rights that a woman has as far as arrest is concerned. No woman can be arrested after sunset and before sunrise. Okay, and if there is there has to be a women constable present at the time of arrest. And also remember, I'll just give you a case where there was this lady complainant who was aware of the provision that only a female police officer can arrest a woman. So when a male police officer came to arrest her in the night, she declined. She declined, and then she went to the police station where she was mistreated. Now, later a lady police officer came, that also she felt now this is the right thing to be done and she should go with that. But there is still another provision which she was not aware of, and that's why she landed in trouble. The other provision was that if the lady officer is there, when a woman is arrested, there has to be, when a lady police officer comes after sunset, then she has to make a written report and receive prior authorization from the judicial magistrate first class, in whose jurisdiction the arrest has to be made. So that she was not aware of. So when the lady police officer came, she went, but she was not aware of the fact that this lady police officer must have an authorization from the magistrate, which she didn't have. And because she was not aware of this right of hers, she went with the lady police constable. She was only aware that the lady constable has to come after sunset and before sunrise. Okay. So, and also we need to know that law prohibits the victims of rape or assault to be forced to go to the police station to record their statement. For pregnant women, all necessary prenatal and postnatal care should be provided to females who are pregnant and who are arrested. Okay, restraints should only be used on pregnant women as a last resort. Okay, the safety of the fetus should never be put at risk, and so that women can never be restrained during labor. So there are these special rights of the women. She has to be kept in a separate cell, not with men, in a separate cell in the police station, separate lockup, and she has to be medically examined under the supervision of a female registered medical practitioner. Okay, and these rules need to be abided by, otherwise she can complain to the higher authorities. So this is all we should be aware of as far as arrest is concerned. Then there are two small things that I would like to say before I pass on to Smita, is about police custody and judicial custody. You must be remembering now, must have heard in the news many times, so-and-so was arrested and now was in police custody and then went to the judicial custody after, after about 15 days or 7 days, went to judicial custody. So many cases have come recently, which were, well-known cases, highlight cases in the media. Arnab's case, Ria's case, all those cases came. When they got police custody, and after police custody, they had to go to judicial custody. So police custody means that the accused stays in a lockup of the police station. Okay, so in the custody of the investigating agency, that's the police or the NCB, whoever it is. On the other hand, judicial custody means that the accused is lodged in a jail. So when Arnab was in judicial custody, he went to Taloja jail. Or when Ria was in judicial custody, she went to the women's jail in Bhaikala. Okay, but in police custody, they were under the NCB custody, or they were in the police station who had arrested them. So the difference between the police custody and judicial custody, that in police custody, since you are under the investigating agency, you can be interrogated in the police during the police custody. But in judicial custody, they need to get the permission of the magistrate to interrogate you in judicial custody. Okay, so police custody can be extended for a maximum period of 15 days. Judicial custody generally can be extended to a period of 90 days. And for offenses punishable with more than 10 years of imprisonment, and otherwise 60 days for all other offenses. So this is generally the difference between judicial custody and police custody. So I think I'll stop here and I'll get it back to Smita.
Thank you, Miss. That's brilliant. Kanti, I think there are some inputs that you would want to add in what Asha ma'am just mentioned.
Oh, thanks, Sweta. I think Professor Asha Bajpai has covered it very well. Just like to add the fresh practical improvements that have come into the system. One is, since I presume that most of the invitees are from Delhi and Gurgaon, there are special cells now for registering the first information complaint from the victims in Delhi and Haryana, Gurgaon particularly, where there are special cells from the police to record their first information complaint. Secondly, I think there is this misnomer that first information report is filed. You file the complaint and the police registers the FIR. You don't file the FIR. Police registers the FIR. So when you file I think Asha ma'am covered it very well in that instance that she gave. That's the third point that I would like to mention. That when you file the first information complaint, please detail the offense in as much detail as possible, because that will only determine the grievousness and seriousness of the offense. A cursory description of the offense often leads to it being treated as NC, while it could be. So I think that's something that any victim should think about it, that it should be as much descriptive and give details. Fourthly, and very importantly, in Delhi, now you can file the first information complaint on online system also. You don't have to really visit the police station. That's something that has happened in Delhi. I don't know about other states. I practice here, so I know about Delhi. And the fifth part is that while ma'am did say that yes, you can file Nancy and first information complaint online in Bangalore. I know Bangalore. I have practiced there. And the fifth and the last point is that while ma'am did say that when you file the complaint, if the FIR is not registered, you should immediately take the matter to the SP. That's the internal process. What we call police guidelines. This is not there in CRPC or IPC. It is internal police manual of the Delhi. Again, I'm talking of Delhi and not of other states, please, because that's where I practice. The police manual says that if you do not get your police complaint converted into FIR for a serious or grievous offense, which is cognizable as per schedule, then you can file it to the SP. And if the SP also doesn't, in 15 days does not take it, then you can make a complaint to the magistrate under section 200 of the CRPC. And then the magistrate will direct the police immediately if it is a serious and grievous offense. And Delhi courts are very particular about it to take notice of it, particularly in the case of offenses against women. Sixthly, I think the general description for you, everybody to understand is that a bailable offense is one which has an imprisonment term of less than 2 years, and non-bailable offenses for more than 2 years. That's general description. I think rest she has covered it very well.
May I just add something, since Kanti has talked about Delhi, Maharashtra also has online complaint.
Okay, so I practice here in Delhi, so I don't know.
Okay, so Maharashtra also has online complaint, and you go to the website of the Maharashtra police, or if you're from Bombay, from Mumbai police, and click on online complaint, give the relevant information there. They ask you all the information, name, offense, all that. So in Maharashtra also, there is online registration of FIRs.
In the chat, they have mentioned even Hyderabad has started. So it's an information for all of us that even Hyderabad has started.
Since there are a couple of advocates here, usually it is first the police custody and then the judicial custody. And the advocates always prefer to take their clients soonest to the judicial custody.
Right.
They will understand why.
Yes.
Yes. I wouldn't like to elaborate on it.
No, I would like to elaborate on that, because when I ask my students just like that before starting my legal, what is NC and what is all that, I asked, would you prefer judicial custody or police custody? Since they have no idea at that time, many of them say police custody. Some of them, smart ones, do say judicial custody. But then police custody is where you can be interrogated by the police or the investigating agency. Okay, and they can make you wake up the whole night and interrogate you. And while in judicial custody, they have to take the permission of the magistrate, who will tell them when they have to go, what time they have to go, how many hours they can do that. Okay.
So thank you very much. I think that was very, very important, and especially for a group of people who are very naive to this whole system. Thank you for that piece of information. I would want to jump to asking Harish. I'm inviting Harish here, okay, to speak about few laws, criminal laws, which went through changes or amendments after the Nirbhaya that happened. Right? Of course, we know about POSH. POSH took its shape after Nirbhaya, but there were some other laws which also got impacted. We'll speak about POSH separately. Harish, you're there. Would you want to start?
Thank you, Smita, for inviting and this wonderful opportunity. So I have a few slides on the topic, what you're saying. Let me have is this visible?
Yes, it is.
So, post Nirbhaya case, there was Honorable Justice Verma, the late Justice Verma, who was appointed by the Government of India to look into the existing legislations and what improvement is needed. So accordingly, he took into account the submissions of lay people across the country. And based on that, whatever recommendations were given, these were the laws which were passed. And in the existing IPC, Indian Penal Code, Indian Evidence Act, and other laws related to sexual offenses. Now, which are these? There are 3-4 which every woman should be aware. One is Section 354A. Since you mentioned, Smita, about POSH Act, which will be covered shortly. So POSH Act, by and large, people know that it's a civil law, right? But we know that suppose if an aggrieved woman has put up a complaint internally in her organization, and she's not satisfied with that, so she can take the criminal recourse. Now, this is what is the law, Section 354A, which the language is sexual harassment, and which is defined in the following 4 ways. So physical contact and advances involving unwelcome, explicit sexual overtures, demand or request for sexual favors, showing pornography against the will of women, making sexually colored remarks. So all of us who know about the POSH law knows that all these 4 things are covered in the civil law of POSH 2013. So the same wordings or the meanings are given to this section. What is the difference? Here the word is only sexual harassment. It's not sexual harassment at workplace. So which means this sexual harassment can be anywhere, and a woman can file under 354A a complaint. And what are the repercussions? So if the first 3 acts which are listed here, if it is found that they were true, then the punishment is 3 years imprisonment or with fine. For the last act, which is on making sexually colored remarks, the fine, imprisonment could be 1 year or with fine. So this is the first important amendment. The second one was 354D, which is related to stalking. Now in this, the meaning of stalking is given, which is physical stalking as well as online stalking. So following a woman and a contact or attempts to contact a woman despite a clear indication of disinterest by such woman. Now that is very important point in the law. The woman aggrieved should express her disinterest, only then it will be taken as a cognizable under this 354D. Now, the second part is about use of internet, email, and other form. Now, in this case also, so post Nirbhaya, there was a lot of clamor that there should be stricter punishment. but often the lay woman or the lay public is not aware what are those punishments. So in this case, if it is stalking online or physical, it is bailable maybe the first time with 3 years punishment and fine. But second time, if it happens, then it is non-bailable and the punishment can go up to 5 years and fine. Let's go to the next one, which is important related to the law of rape, which is section 375. Now, often we know that the rape law, which is there in our country, it talks about forceful peno-vaginal intercourse as the basis, as the important marker. Whereas here, the amendment or the things which were added were these, that if there is forceful anal or oral sex, then also it will be seen as something falling under rape. The second part, which is which there's a case which has happened, that insert to any extent any object or a part of the body, including fingers, into the vagina, urethra, anus of a woman, or makes her to do with other person. Some of you might be knowing that the Tarun Tejpal case, which had occurred in Goa. So Tarun Tejpal is accused of rape, not just sexual harassment, but rape, because he put it in his fingers inside the vagina of the woman. And if anything such thing is there is against her will, without her consent, or even consent which is forcefully obtained, it will amount to rape. Now in this, what is the strictest punishment? So minimum 7 years. So judges also have no say now. They will have to give minimum punishment of 7 years, but worst comes to worst, the punishment will be life imprisonment as per this amendment. That's it. I think I'll come to the other two laws which were mentioned also in the chat box after a while. Thank you, Smita.
Thank you so much. That was quite informative. Thank you very, very much, Harish. Now, I want to move your attention all, because there are a lot of people from corporate here. So I want to move you.
If I may intervene,
Yes.
just intervene.
Yes.
That
yes.
is from corporate side only.
Yes.
So what Harish ji said is very, very relevant as far as 354A is concerned. So what's happening in corporates also, that the corporates are now getting more worried. So both POSH and 354A can go parallelly.
Yeah.
And I know one very large publication company who happened to be our client for that particular occurrence, where the females were pursuing more the 354A remedy than the POSH remedy. And the issue was that in a 354A remedy, you don't have to necessarily give the descriptions of the offender as against a POSH complaint. And therefore, the police straight away was going to the board of directors and owners of the publication company. And that was quite, I would say bothersome for the board of directors. But at the same time, it led to quick initiatives into creating a safe and a secure environment for the working women. So that's very, very interesting.
May I just add to Kanti very briefly, very quickly? Harish mentioned about 354A, 354B, 375, 376. Now, in these cases, it has to be a women police officer who has to register a complaint. I wanted to say that. And there is a question in the chat box about whether Gujarat has an online complaint. Yes, Gujarat has an online complaint. So whichever state you are in, go to the website of the police in that state and you will come to know many states are now having online FIRs.
All right, Smita, that's
that's brilliant. So coming back to, and I'm being mindful of time and I'm clearly rushing y'all into it, but there are so many pointers. And I realized, when all four of you got together and we were discussing about women's rights, I realized one session is not enough. And we might have to split it and come in 3-4 sessions to discuss and go on discussing about it. But then I was very, very keen, and I am very, very keen to touch upon many aspects as much as possible. So I'll move to corporate laws which impact women. So I invite Aishwarya here, who is been specializing, and Kanti also, who's been specializing working in on the other side of being a organization, from the organization perspective. So Aishwarya, which are those couple of laws which you would want to share, and you think that women should know about their rights when they are in an organization?
So before I answer your question, I think I just want to first thank you for giving me such an incredibly warm welcome to the session. Okay, to answer your question, I think I'll be addressing two laws in particular. One is the Maternity Benefit Act and the provisions under it which are relevant to women workers. And second would be the Medical Termination of Pregnancy Act. So if you look at the Maternity Benefit Act, or MBA, of 1961, it stems from our constitution, actually Article 42, which talks about providing humane conditions of work and maternity relief. In terms of applicability, I would say it applies to all establishments, be it governmental, non-governmental, in the private sector, as long as such an establishment employs 10 or more women, 10 or more employees, this act is applicable. So more than the act in itself, I think in 2017, there was an amendment that was touted to be a game changer because it brought in a lot of, given how far we'd come in as a society, as how much we'd progressed, there were a lot of changes that were necessary. And I think some of the key highlights are, one is the paid maternity leave, which was earlier just limited to 12 weeks, now was now extended to 26 weeks. And secondly, and I think this is very important, for adopting mothers as well as commissioning mothers. Commissioning mothers are ones who opt for surrogacy and who have children through surrogacy. They were also recognized under this act, and and now they are allowed for a paid maternity leave of 12 weeks. And I think the third important point is, especially in this post-pandemic scenario, is how, of course, with the mutual consent of the employer, a new mother can actually opt for work from home option even after the maternity leave period has actually ended. And I think fourth important point was, any establishment which has more than 50 employees is mandatorily required to have a creche facility, a daycare center of sorts, so that women who do not have support at home can actually leave their kids there and also be ensured about their safety. In terms of important provisions, I would say is Section 11, which allows for women to take nursing breaks during their work hours whenever required, and Section 12, which protects women from being dismissed during their course of pregnancy, as well as during the maternity leave period. But there was one thing I think our legislators failed to take note of. I mean, the sort of loophole I would say in this is our economy. Given our economy, I mean, we have a lot of small businesses, and it's very, very difficult for employers, especially with regard to these small businesses, to sponsor someone without paying them for without having them work for 26 weeks. I mean, it takes a toll on their financials as well. So this resulted in a very counterproductive effect of employers not recruiting women, and which only worsened the situation. As a solution, actually, in 2018, the Ministry of Labor and Employment introduced the Maternity Leave Incentive Scheme, wherein employers, as long as they paid the 26 weeks worth of maternity relief that was there for the women and followed some other conditions, they were entitled to 7 weeks worth of reimbursement from the government. Of course, this scheme has not yet seen the light of day. I mean, there are a lot of technical and regulatory aspects that still have to be confirmed. So once that is, I'm hoping, and I think this will be a little relief on the employer's part as well. The next, and I'm sure all of you would have heard of the labor codes, I'm sure. And one of the labor codes is the Code of Social Security 2021. And once this code comes into effect, it was actually supposed to come into effect in April 2021, but because of the pandemic and the elections in different states and quite a few other reasons, it still hasn't come into effect. But Once it does, the Maternity Benefit Act will actually be subsumed into this new Social Security Code, which means that earlier the rights that these women can no longer seek the rights under the Act, rather they have to resort to the provisions under the code. Of course, the code has been modified a little bit here and there as opposed to the Act. One, I think I'll just quickly highlight a couple of points. One is the Aadhaar card. Earlier under the Act, that was not a requirement. But now any woman, especially in the unorganized sector, is supposed to show her Aadhaar identity card to seek benefits under this Act. Second would be in terms of punishment. So earlier under the Act, for any employer who was not providing or fails to provide the maternity benefits under the Act, he or she was subject to a minimum imprisonment of not less than 3 months. But now this has been changed to say that it's to a maximum extent of 6 months. And third would be who can lodge the complaint. So under the old act, you could have the woman who was aggrieved under the act, or the inspector who's been appointed under the respective state, or even a registered an office bearer of a registered trade union where the aggrieved woman is a part of that organization. But now that the last part has been removed, as in no longer can an office bearer of a trade union be a complainant to this to any issue under the Maternity Benefit Act. So I think now moving on to the second act, which is the Medical Termination of Pregnancy Act. I think there's a lot of, when it comes to termination of pregnancy, there's generally a lot of stigma, not just in India, across the world. And there's a lot of ethical conundrum that is there and social stigma that people have faced. And that is why we had the MTP Act of 1971 introduced. But it had a lot of, it was not very inclusive in terms of who could get the abortion done. There was a lot of unsafe and illegal practices that were going on, which often led to botched abortions, which had long-term health complications on the woman, which even sometimes led to death. So given the advancement in the medical field of medical science today, actually there's this the very recent amendment, the MTP Amendment Act of 2021, which was actually given given effect as of March 2021. In that, there are quite a few changes which I think are very crucial, and it is a step in the right direction and gives more autonomy when it comes to a woman, and where she has more say when it comes to her own body and what she wants to do with it. One example in this new Amendment Act, I would say, is the upper limit of the gestational period has been moved from earlier it was 12 weeks. Now it's been moved to 20 weeks. And in case of vulnerable women, it's moved to 24 weeks. But by vulnerable women, I mean women who are rape victims, victims of incest. And unfortunately, these kind of cases are more in our country, if I'm not wrong. And then you have minors or disabled women. So these women are categorized as vulnerable women. And in their case, abortion is allowed up to 24 weeks. And earlier, where two practitioners, medical practitioners' consent was required or opinion was required, now it has been reduced and dialed back to one. So I think that is a very positive move. Second, the terminology. This is something that everybody should take note of, because earlier under the MTP Act, it was defined as married woman and her husband. But now it has been amended to say a woman and her partner. This term switch in terminology, I think, is very crucial, because it means it now brings unmarried women as well under their ambit, which is very, very important in our country, I feel. And one more new section has been inserted, which is Section 5A, which penalizes any medical practitioner who fails to protect the privacy and the confidentiality of the woman who is seeking to terminate her pregnancy. I think this is also very crucial given a very victim shaming culture that we have. And last, even in case of very exceptional cases where there is substantial fetal abnormalities which has been diagnosed by a medical board, the upper limit on till when the abortion can be carried out has been removed. So these are all some good changes that have come up. I'm just hoping that execution wise also it's carried out in a good manner. So
yeah, that's a big question, I guess, how
yeah.
it will be executed. And a lot of chat saying, in fact, was Lakshmi pointed out that how she was terminated because they did not want to continue with her employment because she was expecting a baby. So that's really, really sad. And execution is big challenge. But at least, what I feel is that sensitivity has come. You mentioned some very beautiful points like it is not married woman, it's woman. Okay, these are very sensitive pointers, and I think we are going there. Yes, how, where, when is a big question, but at least the journey has started. All right. So thank you for that, Kanti. I am going to quickly come to you for few other inputs that we discussed about, maybe POSH, bullying, harassment. These are some important aspects that you could highlight.
So, POSH is now, I think, overly debated and discussed subject. But my learnings over last 5 years in the field of POSH is, I think I'll categorize the POSH practical issues into 3 buckets. One is the whether the companies are creating safe and secure environment, and the environment is not turning hostile, and or are the awareness sessions only for the purposes of compliance under the Act? I think that's something that I will like to talk about, even for some of the good organizations that I have seen. Second is, assuming that an inquiry committee has determined and found out the offense and punished the offender, what happens to the post-life victim, employment life of the victim in the same organization? That's some people are, and there have been a couple of cases in that regard also. And the third part is, does that stigma of having filed a POSH complaint moves from organization to organization, means from employer to employer, and employer sees the POSH complainant as someone who is a troublemaker rather than a victim who has got his the offenses remedied. I think these are the 3 practical issues that anybody and everybody who is practicing in POSH law, and is also some of the fellow speakers and other participants, should think through as to how to prevent this kind of unfair treatment to the POSH victims. That's something that I will like to bring. So the first part, let's say, the carrot and stick theory. And I'm not elaborating these because I believe every participant is quite informed about carrot and stick theory, that the boss shows that I'll take you to a foreign trip, I'll give you promotion, I'll do your appraisal, and if you don't do it, this is what you face. Now, at something that the new entrance to the, okay, what somebody says, Mahbano says, what is POSH law? Okay, so I assume that since she was saying that she has done a lot of sessions, that's
I think yeah, it's perfectly fine, and thank you for bringing that question. Please, Kanti, just take 1 minute to explain what is POSH law, because this is so important.
So this is a 2013 Act which got notified in, I think, December 2014. Which is sexual harassment of women at workplace, and it deals with 3 aspects. I think that's, people who look at POSH don't look at those 3 aspects. It looks at prevention, it looks at prohibition, and it looks at redressal. So prevention is first part, where an ICC. So is that clear to the participant who asked that question? It is sexual harassment of women at workplace, prevention, prohibition, and redressal act. Okay, so that's one part. Now, I'm not getting it because I assumed during my initial sessions with Smita that people now know the definition of the extended workplace, which is something very, very important that has come about in the POSH Act. But what we were getting into, and let's start with that first bracket. And Smita, you stop me where I go overboard, please. Okay?
Yes.
So typically in MNCs and metros, I see a lot of new female employees come from small towns and rural areas, let us say from Bihar. And when they enter into a new environment and they see that people are very open, they at times are not very comfortable with some of the advances that are being made to them by their superiors or peers, but they feel that this is part of their life in the corporate environment. They have to live with it and they have to adjust it, as they will be treated as backward. And that's one dilemma that we all informed participants and who are working for women rights should clear that out, that any action, whether symbolic or otherwise, which makes a woman uncomfortable at the workplace, she should immediately report, because whether that is sexual or not, it will either get into a POSH Act or into the Disciplinary Inquiry Act. So I think that's something that I have seen a lot of women undergoing the sexual harassment, is that because they think that this is part of the process of their getting modern or getting adapted to the metro city environment or the work environment of an open workplace. And that's not the case. I actually recently in inquiry as a ICC member noticed that one computer engineer from a city of Allahabad underwent such kind of sexual advances for a period of 3 years, because she was always told that, she is coming from the small city and doesn't understand the work of the big city environment. So that's something that we, although the courts have been very clear that the inquiry committee and courts should therefore get into the sensitivity of the complaints and understand that even though a woman has accepted it, was that acceptance under carrot or stick or pressure or due to other hostile environment? So any inquiry committee member or any ICC member, who does the awareness session or is otherwise involved in pursuing, must look into the nuances of the hostile environment. That's my first message. And I would also say that we must advise the women and the female employees to report their incidents at the first instance.
Absolutely. So I must, Kanti, share with you one case which
Yes,
recently I dealt with. I'm really sorry for taking this time out, but the exchange of message between a woman and a man was as simple as somebody sending a message by 9:30 and saying something like, hey, baby, something like that, right? And that woman immediately blocked him and next day reported, right? When the IC committee, the internal committee looked at it, they said, it's not a very severe offense. That itself, I think, is a wrong attitude.
Which is why I'm saying the ICC has to understand the sensitivities. And the courts have in the past, after the Vishaka judgment and before the 2013 Act, have passed in a number of verdicts that the court should look into the sensitivities and understand the nuances of a hostile environment. The second thing, as you rightly put it, the social media, the boss or the colleague would ask you to be a Facebook friend, and then they will take leverage of it. Now will that come under the workplace or not? The courts have not decided yet. But if it affects a work, if the relationship is coming out of due to a work environment, to my mind, it has to go to an extended workplace definition, although there are no specific judgments on it. That's another thing that I will like to share with my friends here. The third thing is the inquiry. So a victim has made a complaint. Assume this is a simple case. A victim has made a complaint. Absolutely, Harish is saying that the context plays an important, but Harish, the thing is that in a context for a period of time, it is very difficult to understand the context. So the ICC members have to be sensitive to it. And I appreciate what you're saying. The context is important, but context becomes very subjective at times. Each ICC member has a different lens to see the context.
So I can I add this? So
Yes,
when I
please.
say
You're welcome.
context, when I say context, I meant that, since you gave that example that a
And
senior
these
colleague,
are real life examples.
right? So you mentioned that example, a senior colleague is requesting for a Facebook request, and after that they are in constant touch. So when I say context, it's in that how are they knowing each other? They are not
Absolutely.
knowing as unknown people. They are knowing as colleagues. And after that, he has put up a request.
Which is the reason I'm saying that therefore it should
Correct.
come into the definition of the extended workplace. But there are no
Hmm.
judgments on it. That's all I was clarifying. I agree with you. So that's the second bucket that I wish to put in. Smita, how much time do I have? Because it's already 8:11.
Yes, we have spilled over our time. So quick, if we could wrap this up, because we have so many things packed in. Yeah.
Yeah. So I think, yes, somebody has said a very thing, Lakshmi. That's correct. But I think it's also, how the ICC and the advisors to the ICC create those awareness sessions. That's very, very important. Um, Third, the second point I was saying was, and let me wrap it up in the next 3 minutes, is assuming that the inquiry has been held and the offender has been punished. What happens to the victim now? Does she get the same fair treatment or not? And if she does not get it, unfortunately, in many of the instances, it does not happen, and she leaves the environment because the peer pressure and the environment is not so good. My suggestion in this regard to women employees has always been that, don't think that POSH is a remedy for, is a panacea for all your, grievances. There is a disciplinary committee also. So if you find that the hostile environment is not sexual, but it's otherwise, please do not bear it. And in the first instance itself, put a right complaint either in that bracket or in the other bracket. And I'm talking more of the organized sector rather than unorganized sector, and we will some other day time deal with. So this can be elaborated, but let me finish it here. The third bracket is when, if assuming you are a victim, you made a complaint, the offender has been punished, and because of the hostile environment, not so conducive environment, you also leave. And now the new employer wants a reference. And that reference is not very good. The reference checks are always part of the HR system. Smita would know it better than me. And that's where the ICC also has a role to play. They have to create that this thing, that the complaint is confidential and any ramifications out of it cannot be made as part of the reference check. I think I like to limit here. There are all the more implications, but it's already 8:15. So thank you very much for giving me this opportunity, Smita.
Thank you so much.
They have been putting so many good questions.
So many questions, so many amazing questions. I want to respond to all, but we really have lack of time. But we would, if y'all are interested, carry on this conversation, because we had quite a packed this. I would want actually, Aishwarya, if you could add about equal remuneration. I think you didn't speak about equal remuneration. Would you want to put in some inputs on that? Because right to equal remuneration is something that in corporate, which is very, very important for women employees.
Right. That's very correct, actually.
Did we lose her? Aishwarya, we can't hear you. Anybody else wanting to take that, or should we move to another?
So Equal Remuneration Act is actually also coming out of the Constitution.
Yes.
It's right of equality, which is Article 14, and then the Equal Remuneration Act was promulgated, which is that for the same position.
I think I lost you guys in between.
Yeah, if Aishwarya has come back, I would rather like to speak on her topic, but I was just trying to support her.
Has she come back?
No, I don't think so. Aishwarya, are you back? No, we can't hear you if you're back. No worries. Let's do this, Kanti. If she comes back, we will get back to you. Asha ma'am, I would want you to tell us about right to privacy. Really crisp, short. What does right to privacy mean? What happens is we are in a conversation. Somebody is clicking my pictures. Somebody is just asking me too many personal questions. What is right to privacy all about?
Yes, I'm not going into my PowerPoint. I'll just quickly talk about it because of the shortage of time. Right to privacy means right to be left alone. That's a very brief, simple definition of privacy, right to be left alone. So it is the objective generally is that you protect citizens from arbitrary intervention of the state or the people, authorities or actors or whoever they are. It helps create boundaries and preserves the legal rights of people. For example, for sexual assault victims, for victims of rape, for victims of harassment, their identity is not disclosed. That is as per the law. Even if you see the law, the rape law, or for the sexual harassment law, you cannot disclose the identity of the victim. So this is also one aspect of right to privacy. Right to privacy is considered as a human right in many international law, many international instruments. Right to privacy is considered as a human right. In our country, in the constitution, you do not have a specific right to privacy mentioned as such, but it is flown from Article 21, which is right to life. Right to life it flows from that. There has been recent two important judgments from which you can infer the right to privacy. One was in 2017, the famous Puttaswamy judgment by the Supreme Court, in which the Aadhaar card scheme was challenged on the ground that it collects data and compiles data of the residents of the country and used for various purposes, and which is a breach of fundamental right to privacy, which is there in Article 21 of the Constitution. But the Supreme Court referred this matter to the constitutional bench, and it held that though right to privacy is not very specifically mentioned, but it flows out of various fundamental rights in the Constitution, like 14, 19, 20, and 21. Basically, Article 21, and that is why it is a right, it is a fundamental right. So this is a very important judgment of the Supreme Court that right to privacy is now a fundamental right in India. Okay, so because of this, we have to, there has to be a law now to make it absolutely legal. And they also said very clearly in the Puttaswamy judgment that human existence is not a mere existence, and every person deserves to have a dignified life. Dignified life and privacy is the utmost significant factor regarding the enjoyment of dignified life. This is what the Supreme Court said. Then there is another important judgment followed by it in next year. That means in 2018. It was Navtej Singh Johhar's judgment. We all call it Navtej Singh Johar and Puttaswamy judgment. These are two very, very important judgments as far as right to privacy is concerned. I'm going very fast because of the constraints of time.
No, I think, ma'am, what I'm going to do is after our today's session, call out all the participants who are there and ask them which are those laws that you want us to spend a little more time on. And if y'all are okay, bring y'all back and have this discussion again.
I'll just quickly wind this up, Pasmita, what I was saying about Navtej Singh Johhar's case, because it is a very important judgment which said that the government had no right to intervene in the lives of individuals based on their sexual intent. That means what kind of sexual identification or identity you have, that is not the business of any government. You can follow whatever sexual identity you want to have. But one more thing that has come in the question also in the chat box also, which I would like to add. So now after these two judgments, we are saying that decriminalization of homosexuality is happening will happen in India, and also we need to have a law on privacy. And this means that women should be allowed to make her own decisions, and she should be entitled to express her feelings. This is a fundamental right, and she should be protesting against any wrongdoing against her. But there is one thing which is there, and that is marital rape. Marital rape now, after these two judgments, it is very clear that the marital rape that is there, which is not yet recognized as an offense in our country, should go. Because in the independent thought judgment that came recently, below 18, they recognize marital rape. But after above 18, there is no recognition of marital rape. That means a husband having sexual relation with the wife without her consent. That is allowed in India if she's above 18. Below 18 is taken care of now with the judgment. But above 18, we don't have this recognition of marital rape as an offense. But after these two judgments of Puttaswamy and the Navdeep Singh Johar case, we need to see to it that since right to privacy is a fundamental right, marital rape now should be recognized as an offense in the Indian legal system. This is what I wanted to say. I think there was a question on that in the chat.
They are quite eye-opening conversations that we are having. Though I've been working in this space, some of them were really eye-opening for all of us. So I would like to invite, I think Aishwarya is back. I would want her to touch upon cybercrime. Aishwarya, would you want to share? I know we had question about for you on Equal Remuneration Act and cybercrime, if you could touch upon those two aspects.
Sure. Sorry, there was some technical glitch from my side, but I'll try to keep this short. But I've also read on the comment that I was a little fast, so I'll try to not rush things, but also answer it in a crisp way. So with regard to Equal Remuneration Act, I mean, as the name of the act itself suggests, it's just equal pay for equal work is what we're striving to achieve. And this has been an issue that it's been going on for quite a while now. So I think under the Equal Remuneration Act, the employer is legally obligated to pay the same wages for both a female as well as a male employee, and and as long as they're performing the same task or in the same position at work, he or she is legally obliged to pay the same wages. And there can be no discrimination in terms of recruitment, training, transfer, or any other terms of employment. There can be no discrimination on the basis of gender. So I think I'll just quickly skip to how the new code works in terms of the Equal Remuneration Act. So this is being subsumed into the wage code of 2019. And some changes that have come across is the limitation period for filing a complaint under this act for any breach has been increased to 3 years now. And secondly, if you look at the terminology, that has undergone quite a change, where it earlier used to say that it only talks about discrimination in terms of recruitment or transfers, promotions, etc. Here, the terminology used in the code is general conditions of employment, which means it's a very inclusive definition where there's more scope of, I mean, I think the legislators did not want to restrict the scope of what amounted to discrimination in the workplace. So I think that is a very wise move on their part. And the third thing is with regard to punishment. Earlier, it was just imprisonment up to 1 year and fines up to 20,000. But here they have split it into employers who are paying less than what is due, and employers who are not following the other provisions of the code. But the term of imprisonment has actually been reduced in both cases in terms of the code. Now, coming to answer the question on cybercrime, I think all of you would agree that the internet is truly the town square of the 21st century. And unfortunately, some, if not most of us, even in this session today, have faced some sort of online abuse or cyber harassment. It's unfortunate, but it is true. So, in fact, I was reading up on an article about 2-3 days back where 200 very well-renowned women across the world have written a very open and very strong letter to the Worldwide Forum addressing the need to prioritize the safety of women online. And even tech giants like Google, Twitter, TikTok, and even Facebook have come up with a set of commitments that would help women feel more safe in the online platform. But the question arises as to what exactly is cyber harassment or online abuse. So it's an umbrella term, and it has so many things under it. Anything which makes you uncomfortable, like cyber stalking, like Hari sir was talking about stalking even online, and cyber bullying and victim shaming, disparaging the modesty of a woman, and impersonation, misinformation, just to name a few off the top of my head. I think it's just an umbrella term to say online abuse. But in terms of, I think, coming back to India, some of the laws were first, I think, recognized under the Information Technology Act. More specifically, the 2008 amendment which came up specifically addressed a lot of these issues. So I'll just quickly walk you through some of the provisions that are relevant to the online harassment. So if you look at section 66A, it talks about and addresses and provides for punishment for cyberbullying. And if you look at section 66C, it talks about punishment for identity theft. And if you look at section 66E, which I think is very crucial, especially in the online forum, where a person intentionally or knowingly transmits or publishes or captures the private areas of a person without their consent, that again is a punishable offense. And section 67 of the 2008 Amendment Act is also very crucial in the sense that, and it's a punishable offense for publishing or transmitting obscene material in any electronic form. And I think section 67A-B also talk about publishing or transmitting of material containing sexually explicit acts in an electronic media. And section 67B talks about the same thing in terms of children. And it's very unfortunate, but this is also something we have to address. But what is the redressal mechanism that is there, or what are the options that are there in front of a victim who has gone through online abuse or who suffered cyber harassment or cyberbullying? So one is actually it is an initiative of the Ministry of Home Affairs, where they have started a national cybercrime reporting portal, wherein the victims of online abuse can actually go report their issue. And I think one important point about this portal is the option of anonymity. I mean, given our culture of victim shaming, especially in the online forum, if you look at the girls' locker room issue that came up in quite recently, there was a lot of victim shaming that was involved. So this, I think, cybercrime portal is a very good initiative by the government, where you have the option of reporting anonymously. In case online is not an option for the woman in question, they can also approach the tradition. I mean, they can opt for the traditional offline method, that is approaching the police station, as Ms. Asha ma'am had beautifully explained how all the rights work. I don't want to bore you guys again with the details, but any cognizable offense, and the police police station is required to file an FIR. And in case if that is not happening, the woman or the aggrieved person can actually approach the judicial magistrate in the district and have them direct the police officer to take up the investigation. But I think overall, cybercrime wise, there are laws in place even in India. But I think when it comes to execution, like for every other law, that's where we are falling short. And there's also a lot of social stigma that comes with it. I think it's a blend of all these things together that have to come together so that we take a step forward in the right direction.
Amazing points made, Aishwarya, and I think it is so enlightening. I think we should dedicate one time for cybercrime itself, and I think we'll get a lot of questions there. Cyberbullying and online, Shreya is mentioning, right? So I would want quickly to invite Harish about the most talked about topic is domestic violence. Harish, would you come back and share with us your take on domestic violence?
Along with the Domestic Violence Act, there's another law also on which I wanted to quickly touch. It's just one slide each. Let me just... So is this visible? Yeah.
Yes,
so
yes.
Prior to the DV Act, the Domestic Violence Act, in terms of years also sequencing, first came 1994, an important law which is shortly called as PCPNDT, and it stands for Preconception and Prenatal Diagnostic Techniques Act. So, you know, earlier Aishwarya talked about the MTP Act, which is medical termination of pregnancy. So, but this act came specifically if the termination is after finding out whether the would-be fetus, would-be child is going to be a female. All of us know that, you know, this is related to the declining sex ratio in our country. So systematically there are abortions of unwanted girls. And so this act came first, actually, it was only PNDT Act in Maharashtra. And after a lot of struggle by women's groups across the country, Then there was a refined act called as PCPNDT. So it prohibits pre-sex selection. Now, it's very important that people might think prenatal diagnostics, that if a woman is pregnant and then she goes for testing, and if at that time a doctor or a medical person identifies the sex and communicates about it, that is definitely taken in the ambit of law. But what is added is pre-sex selection. That means even before the woman is pregnant, there's no dearth of such doctors who would say that, come to me, I will ensure that you will beget only a male child. So to put such doctors also in the ambit, the word preconception was added. So I think this is important. And, some of us know very well that when you go to a maternity home or a nursing home, as per the law, mandatorily, there should be a board put up prominently, which says that just as in POSH, there's a board required as per the mandatory law. Similarly, a board is required here that no sex selection will be done here, and that should be prominently put up in the nursing home. So this is about the PCPNDT law, which many women are unaware. So coming to the PWDVA, which is Protection of Women Against Domestic Violence Act, this came in 2005, which is after so many years of struggle by the women's movement. Because prior to this, as somebody mentioned in the chat box, there was only section 498A of the IPC, which was seen as a draconian law by some of us, and which did not give justice, including all women. So this law, these are the salient features. That one is, this law first time defined what are the different forms of domestic violence. It talked about physical, psychological, verbal, financial, and it also talked about sexual. So let me talk a little bit after a while that even if the word sexual is given, you will find in India, there will be a dearth of women who would go and put up a complaint on domestic violence, saying that I want to make a complaint specifically on sexual violence by my husband. There will be very few such examples. So it will be either coupled with physical and psychological, and she may not verbally talk about sexual abuse. But nonetheless, if the question is, earlier it was raised, on one side, there is no law on rape, marital rape in our country as of now. It remains to see that if there are some cases where under sexual violence, if a woman has registered against a husband, what sort of intervention is provided and remedy provided to her. So I think it remains to be seen, but nonetheless, so it covers sexual violence in some way in this law. And most importantly, this law is a civil law, not a criminal law. It doesn't treat the husband as a criminal that henceforth he cannot change. It gives an opportunity for that husband also to improve. But along with that, there are some important features. I think with the paucity of time, I'm just showing 3 bullets, which are very important, that there are protection officers who are specially appointed under this law. There are service providers, which means those social organizations which are legally recognized. Only they have an important role. So they can take the complaint of the aggrieved woman and they can offer legal, medical, and other relief. Now, the 4th important bullet point, which is here, is the right to shared household, which takes care of a very important fear of a large number of countless women in our country. The moment a woman doesn't want normally to put up a complaint and go to a police station, because she fears that the moment she puts up a complaint, she might be asked to leave the home. So this law takes care of that she has every right to stay in that same house where she might have been subjected to some form of domestic violence, but she can also ask for orders by the magistrate, which will say that henceforth I pass a protection order, which is written in the last slide. So the magistrate can specify that even if it's a small house, the magistrate can give such kind of order. And there have been precedents, there have been examples where they have said that one part of the home the woman will stay and the man will not enter that area, that arena. Now imagine how important is this kind of an order, getting that. So it's important that how the service provider intervenes and puts accordingly the complaints, so protection order, residence order, compensation order, these all can be. Now, one important point which is not mentioned in the bullet is, as I was telling, that not just married women, but unmarried women, those girls who are less than 18, including boys who are less than 18, can also fall under and take recourse of this particular act. It also covered women who are, in live-in relationship. So this act was first of its kind, because it went beyond the normal scope. I think I'll stop here. So basically, every woman, now this law, even though we are talking largely about corporate based women, and for them, I would wonder if average educated woman also is aware about this particular law. So I must tell that there was under provision under this law that for the purpose of awareness, there should be a separate fund by the government of India. And sadly speaking, that nobody is asking the question to the government that, they are supposed to prepare brochures, booklets, literature, posters for the lay public so that they are aware about this particular section. Because, we know the gravity. So I'll just come to one point about the marital rape. I mentioned earlier about Justice Verma Commission. So Justice Verma in his submission had mentioned about two important laws, and it's very interesting. One is within the four walls of a home, which was related to marital rape. The other is the AFSPA law, which is the Armed Forces Act, which is on the borders. So none of these laws were touched in the parliament. It's very important that, in a country like this, for us to get the marital rape law, it will take a while. It will shake a lot, because imagine like Maneka Gandhi, a former minister of women and child development, had to say this in the parliament, that in India we don't have a culture of such marital rape. It's a woman minister telling. So and again, the next point is, just as in the case of the Nirbhaya case, when one film was being made by the BBC, and it wasn't allowed in India for the fear that, MLAs and MPs feared that it will open up a Pandora's box. The same thing is here. The moment such a bill is passed, you don't know which of the representatives are subjecting their wives to marital rape. So it will open a Pandora's box, but nonetheless, the debate should happen, which unfortunately, it right now is jinxed. So, these two laws, one is within the home and one is outside the home. As some of you know, that the AFSPA law in Northeast and in some parts of the country, a woman can be searched, her bodily searched, under the pretext of an investigation by a police. So, it's so, and, there have been so many cases of Manorma and others who were tortured, and because of which there was a protest, in Manipur by a large number of women who had come out in the open, removing their clothes. They are telling that, if you want to rape, then, this is what, So, I think a lot of the time will go for these two important laws to really, related to sexual offenses, to really come into seeing the light of the day. It will require a proactive, multi-pronged approach.
May I intervene, Smita, now here?
Yes,
Very quickly. See, after the two judgments which have made right to privacy as a fundamental right, I think the jurisprudence is clear now on bodily integrity and its close connection to right to privacy. So autonomy, dignity, and bodily integrity is going to take precedence over saving a marriage or the institution of marriage. I think we will soon have a legislation on marital rape. And hopefully, though we have, it has taken long, but still I think we are now ready to go in for a law on marital rape.
Wow, that will be amazing, and I am really thankful to all of you because you all have got such important points on table, and that makes me realize that one session is not enough. So I will have to break this down into various sessions and maybe bring you all back. And thank you very much for accepting this and the passion that I could hear today on various work that you have put in to understand this law, simplify this for people. And I also heard Harish saying that the government is not doing enough that they should be doing. And as KELP HR, as the CEO of KELP HR, I would want to actually start an association, start some work around it so that at least we can give back something to the society. If not, start creating awareness for those people who are not able to get awareness for various reasons, right? So this is something that I take it as my on me to get started to do some work. Thank you very much for all your time. Any closing comments from any of you for this discussion today? And thank you very much for staying with me. I know it overspilled time which I had committed, but thank you very much for staying with me. Any closing comments from
I would like to
first say that I've actually been a part of a couple of KELP HR sessions, but on the audience side of things, and I've learned a lot. And today was no different because I learned so much, like be it Asha Ma'am's Zero FIR or Harish Sir's talk. And I'm so glad that we brought up the talk session about marital rape. And like Ms. Smita has been saying, I think each and every topic that we address today requires a session in itself. I think only then we can do justice to it. So I must say that first, I just want to thank all of my fellow panelists and mainly KELP HR and Ms. Smita for putting me onto this and giving me this opportunity. And I think every webinar or session is only as good as its participants. So we had a very lively audience today who posed such interesting questions and comments. So thank you for that. And thank you all for attending the session and being so patient.
Thank you so much.
I'll say some few very quick words. Thank you everybody for, I can get very good questions in the chat box. One question that came in was about women getting maternity benefit in the informal sector. As of now, we are not covered under the Maternity Benefit Act, but there are schemes. There are government schemes for the women in the informal sector. And so I think these schemes, when Smita is working on this issue, the schemes also need to be, made available or give information on the schemes to the people so that they are aware of the schemes that are there. Yes, there are schemes, there are hurdles, you need a lot of documentation and all, but still you must be aware of the schemes and the documentation that are there for women in the informal sector.
Ma'am, I would want to add something here. KELP HR is a very small company, okay? We are less than 20 employees and 95% of us are women. 2 years back, one of our woman employee proceeded on her maternity benefit. It was very easy for us to may not comply, okay? Because we are not a full-fledged 20 plus organization. But we said that we have to do this. And, it could have, financially did not look it looked very difficult for us, but we said, it's fine, we will do it. And we gave that entire 6 months break to her. She did not join after the maternity, but we still went ahead and did that. Okay, so so it's also the employers, employers, we have such a huge amount of unorganized sector. It's about an employer taking a stand saying, I want to make a difference, maybe in my small way, and imagine the multiplied effect it is going to have.
Right, and that's the spirit of the law. Smita, the spirit of the law is not the number game that you have 20 and 30 and 10 employees. The spirit of the law is to take care of a future citizen of our country, to take care of motherhood. That's the intention. That's the spirit of the law that is there, maternity benefit. So we shouldn't go by the number. What you did was absolutely fine. And I also agree that it should be there for organized as well as the unorganized sector. Law should be there for both of them because it's motherhood, it's children, it's child rights of the child also. That is one thing. And also I would like to say that all laws need to be looked at the intention of the law, the spirit of the law, rather than going by the number game. And I think all HRs should understand that it is not the number that is important, the spirit and the intent of the law.
Yeah. Thank you so much. Harish, Kanti, anything from y'all before we close the conversation today?
So may I,
Yeah, please.
Kanti, if you can,
No, please go
ahead. So I just wanted to stress, which I think a point which all of us, the panelists, would like to tell the viewers, the audience, that, we have a lot of progressive legislation in our country, including the Dowry Prohibition Act of 1961, so as old as that, under which taking dowry, receiving dowry, or accepting dowry, or giving dowry, both is prohibited. But you find clandestinely across all sections of society, pan-India, this is a practice which is being, continued. So the law remains on paper. We have had the PCPNDT Act, for which a large number of women's activists have literally given their lifetime. I'm not exaggerating, but that act also, which neighbor will, that law is such that police have very less role to play. It's the role of the awakened citizens, like which citizen will tell that they have found that a woman is asked to go for such sex selective tests and abortions. So it's the awakened citizens. The POSH law is wonderful piece of legislation, believe me, worldwide, not just in India, but worldwide. It is one of the finest. But the question is for the woman to come and make a complaint. That enabling environment will come when something which is lacking across the country. And what is that? Healthy conversations. Those have, I think, just begun. I'm telling with all humility. Working so much, you are working, since I have been working before when the guidelines were there and much before that. So I'm just telling that now the piece of legislation is very much there. But how you can ensure that the people are talking, and for that, for a reassuring environment for the woman, these conversations have to be promoted. And I think today, in a way, through the digital medium, you have tried to do that. So I'll stop here. Thanks.
Thank you, Harish. Kanti?
Yes, so first of all, I think I would like to thank the panelists. I really appreciate the amount of effort that has been put by Professor Asha and Harish ji and Aishwarya. I think that was very, very good. Usually when you go to a webinars, the theoretical base is not so good. And lawyers usually move to case laws and practical side. So this was one very different aspect. And what it also showed was commitment. On the other hand, I would also like to thank the participants. I think wonderful participants. And I think we have been unfair to them. We have not addressed their queries properly. I would say, Smita, if that's possible for you to list down their queries, and maybe on the queries itself, there could be a very good session, because some of the queries have been very, very good and we have not been able to attend to them and give our views on them in a comprehensive way. So I think that's something that I would like to suggest, if that's
sure,
possible,
Kanti.
Because the participants' queries have been interesting and quite inquisitive, which needs to be addressed. I also like to thank you for giving me this opportunity and allowing me to intervene when I need it. So thank you very much. And also to Madhura for sharing this opportunity with me and letting me know this wonderful people, which is really remarkable, because I get to know more lawyers than people who work in advocacy so much. So thank you very much. And overall, wonderful experience for me, and I thank everyone for that.
Thank you so much. That was really warm hosting each one of you. Though few of you all I have worked with, few I got introduced lately. So it has been so engaging and so full of information. I'm bustling with ideas to come up with for next conversation, and you'll hear. So keep tuned in. Please log into Facebook if you use, LinkedIn if you use, to KelpHR KelpHR site and register yourself. You'll keep getting information about it. And if you have any queries, what I'll try and do is as Kanti suggested, try and consolidate all the questions and get responses from them and try and respond back to you. But please stay tuned in. We do this every second Thursday. We come up with some topic for discussion, but I didn't know that this topic is going to be like overwhelming. Thank you very much for this response. Thank you. I'll stop recording and yeah.
Okay, thank you. Bye.